Oh shit! Judge Liman has officially closed the countersuit that Justin Baldoni and the Wayfarer parties brought against Blake Lively and the New York Times. Now, this is only a final judgment for just the countersuit. There's still a separate action where Blake Lively is suing Justin Baldoni and the Wayfarer parties that is currently active. But specifically the $400 million countersuit that got dismissed back in June. Recently, the New York Times knocked on the court door and was like, hey, Judge, this case is over. Can we go ahead and get a final judgment on our part of things so that we can go ahead and use that judgment in future, cases? Because they're currently going after the Wayfarer parties in New York State Court. But the judge could see, he was like, we haven't heard from everybody. So he entered an order and was like, speak now or forever hold your peace. And the only person that replied was Blake Lively and her legal team. The Wayfarer party stayed silent, and there's been speculation, but I have not passed any, because what do I know? I don't know why they didn't respond. So in the orders from today, let's go over what was actually granted, because he didn't give the New York Times what they wanted. He did, however, give Blake Lively what she wanted. So as a part of the countersuit, Blake Lively had pending attorney's fees that she had requested, as well as like anti-SLAPP stuff with the California Civil Code, the same stuff she's trying to get in this other case she had applied to the previous case. What he had granted was Blake Lively requested that her attorney's fees and her California anti-SLAPP motions that she made would be treated as a Rule 59 motion, which means that the appeals clock is paused until those fees motions are decided. So nobody can appeal. Court has to deal with Blake Lively's request for fees before anybody can do so. That's the part he granted. He was like, he even kind of, I'll say it was a little bit of a slight, he even goes, although arriving at this conclusion requires somewhat circuitous route through the federal rules, the court agrees that Blake Lively's unopposed, wink, wink, we're looking at you, Wayfarer parties, approach is appropriate under the circumstances. What Judge Liman did not grant was what the New York Times wanted. They wanted to have their part separated out as Rule 54B, and they wanted a separate partial judgment to be made in their favor, giving them a final judgment in order to use those findings in the New York State Court against the Wayfarer parties. The judge went ahead and did it his own way, and he goes, we'll just add a final judgment to the whole thing. Why not? Now that the case is officially done in the district court, is not going to be fully final until the fees motions are ruled on. So the New York Times, I think, is still a little bit in limbo until they decide, are we going to grant Blake Lively and the Lively parties their fees motions? That California Civil Code 47.1, I think, is a part of it too. That might be a sticky thing. So the too long didn't read. I'll tell you, it was just basically a procedural housekeeping order. It locks everybody right where they're at, keeps them from making any other movements.